Thank you very much, and good afternoon, everyone. It's a great pleasure to be joining you from the UK. Thank you for that introduction. Yes, my background is that I was a practicing lawyer in the UK for many years, and I also practiced as a mediator from when mediation started in the UK back in 1991. But for the last 8 or 9 years, that's all I've done is commercial mediation. So I was quite interested by the title that I've been given for today, which is how to successfully carry out interest-based negotiation without a third party. In other words, without a mediator. So I'm thinking to myself, well, I'm talking myself out of a job here, aren't I? But I thought what might be interesting is to give you the perceptions and what I've learned working as a mediator and undertaking negotiations with third parties all the time, and how, as part of my role, and this happens in virtually every mediation that I do, I have to move people from positions to interests. And I'm going to explain a bit more about what I mean by that. Now, there'll be an opportunity for questions as we at the end, although if anybody's got anything desperate they want to ask, then I will look at the chat if I can from time to time. But at the end, we'll deal with questions. I'm going to hopefully share my screen now. Can I just ask if anyone hasn't muted? It'd be useful just to make sure that you're on mute, because then sometimes we get some background noise. So let me just share my screen, and hopefully you've now got up my my first slide. There's going to be quite a lot of information that I'm going to be giving you during the course of this, and my experience of talks when I've sat in on talks like this is just take what works for you, and don't worry about what doesn't work for you. Hopefully there'll be some tips here that will help you. So we're talking about interest-based negotiation. What do I mean by that? Well, it's quite important that we start off by understanding the difference between a position and an interest. Now, a position is, say you're selling a car or a house, and you say, I want £5,000 for the car. That's your position. But your interest is you want to sell the car. And so if you simply focus on the price, you're going to quickly run into sand, I suspect, with a purchaser, because the purchaser isn't going to want to pay your price. You've got different positions. You want the highest price, the purchaser wants the lowest price. But actually, particularly if it's a nice car and you've decided to get rid of it, you've got similar interests. You want to sell the car, the purchaser wants to buy it. The problem is the position. Now there's a simple example. Let me give you another one. This is quite, let me give you a couple of quite famous examples about what I mean by interest-based negotiation. There were two people fighting over an orange. They both wanted the orange. And of course, they both wanted all the orange. And you look at it and you think, well, they can't both have it. Either one has it or the other has it. But then if you ask them, well, why do you want the orange? One said, well, I want it in order to get the juice, because I love orange juice, and that's why I want the orange. You talk to the other person, well, why do you want the orange? Well, I want it for the peel, because I make marmalade. and I don't want the juice, I want the peel. And the other person says, well, I don't want the peel, I want the juice. And so, you know, in a very simple way, you can see that by stepping back and saying why, you start to move to a different situation. A lot of what we have to do is to separate people from the problem. A lot of the way you approach positions and try and move people away from positions is to understand who you're dealing with. You have to think about, well, who is this person? What do they want? Why are they here? And I'm going to run through a number of different ways in which you can open up this conversation. I think there are three things in particular. There's the whole concept of perception, the way emotions are shown, and communication. And I'm going to deal with each of those in a little more detail. But what I find is really what we're talking about is the need to use open questions. Now, I don't know how familiar you are with the concept of a closed question and an open question. A closed question is something like, did you come home at 6 o'clock last night? Because the answer is yes or no. Or do you want to buy this? Again, it's yes or no. But if you start to use an open question, you say, well, why do you want to buy this? Then all of a sudden, there's no immediate answer. A person starts to give an explanation. And you've got what has been described elsewhere as these your helpful allies in mediation, these 6 questions of what happened, what went on, what went wrong, why is this important, why did it happen, when did it happen, where was this, where were you, how do you feel, how did this happen, and who was involved, who was there. Once you start asking these questions, you start opening up the landscape, and this will be a theme, hopefully, what I'm talking about, of how you open up the landscape to these, and you're continually trying to, as it were, open up the situation so that you can find out more. Very often in a negotiation, people come in with very closed minds. In the world that I inhabit, which is that of legal disputes, people very often have spent a lot of money, they've spent a lot of time, and they spent a lot of time with lawyers refining and defining the dispute down to a very carefully articulated position. And that's very often set out in the legal documents. I commonly get 400 or 500 pages of documents for my mediations, and you read it through, and you realize people have spent an awful lot of time analyzing and pushing people into a position. Because I think one of the problems with the law, and this is obviously the context in which I'm speaking, one of the problems with legal disputes is that life and the law aren't identical. If something goes wrong and you want to find a legal solution, you have to then conform what happened to how the law says it's able to produce an answer. So, for example, if there's been an accident, then you have to find fault, and you have to say, well, someone's wrong. Someone was doing something wrong, and that's obviously the way insurance works. It works on the basis of fault. But a lot of life isn't like that. And what I think one's doing, certainly I'm doing this in my mediation, and I think what you need to do when you are trying to negotiate on an interest base, it's all the time is just to step back and think, well, it may be that they've had to put their interests, what they're after, in a particular way. But is that all there is? And that's why these questions, I think, are really helpful. The way you can open up the situation like that. But the problem is, as soon as you start asking questions, you're running into the difficulties of language. And I'm not talking about different languages in the sense of what we speak, like French and English. I'm talking about how people perceive what they're hearing. Now, there's been a lot of study on this, and a lot of people have written about how people perceive things. And these percentages vary depending on what you read and where you read. But it seems to be generally accepted that when you're listening to a person, the words that they're using only form about 20% of what you're receiving. Now, as lawyers, this is a bit of a surprise, because we spend so much time thinking about the words we use and how we use them. But the reality is that when people are hearing you, they're hearing the words, but they're also hearing they're also hearing the way you're speaking them. They're hearing who you are and how you're speaking them. I think that there's an awful lot of there's a lot of study going on in the moment as to how the brain perceives what we're hearing. And what I've discovered over the 30 years or so that I've been doing these mediations is that people enter into negotiations, and particularly into litigation, which is where my background comes from, because I'm a commercial litigator. They come from it from a position of belief. And now this is, for me, as a trained lawyer, I found this really strange to understand, because I thought, well, no, we're just talking about evidence. We're talking about truth. You present someone with the facts and you present them clearly enough, and they'll see things the same way as you see them. And if they're not seeing them the same way as you see them, then what you need to do is just to present them with more facts, or to present the facts in a different way. But the more I've been involved in the mediation world, and the more I've done negotiation with people from different backgrounds and different circumstances, the more I've come to realize that actually facts are secondary to how people approach problems, and how they approach the resolution of disputes. People go into litigation because they believe in what they're saying. They go into litigation because they believe someone's done something wrong, and they should be, perhaps they should be punished, but in a negotiation, you go into that negotiation because you think you should be compensated as a result of what someone else has done. And what's very interesting is that people are thinking in that way because of their belief structure. Now, I'm not talking about a religious belief structure. I'm talking about how they perceive the facts and what has caused them to enter into the litigation. You have to work on the basis that people don't enter into a dispute, and you'll appreciate that talking about interest-based negotiation, my background is as a litigation lawyer, so forgive me if I'm looking at these negotiations from the point of view of two parties who are in dispute. I'm not sure that what I'm saying differs greatly as to when you've got parties who are just trying to negotiate a deal. But certainly in a dispute, people come into that from a belief that they're in the right and the other person is in the wrong. And what you have to do if you want to change that belief is actually try and get behind it and understand a little bit about why they're thinking like this. Why are they seeing things in a different way from me? Why is their perception different? That can depend on a number of factors. One of the things I think that's really important to try and get to, and that goes back to a slide I showed earlier, separating the people from the problem, is to just remember that you're dealing with individuals. And one of the things I think that can really help you in negotiating is to think about, well, what's their background? In what way are they approaching this? And by that, I mean, not just simply the culture, but perhaps their discipline. So for instance, in my mediations where I'm dealing with lawyers, people who are used to dealing with words, then that's fine. I may just use words, or I may use a PowerPoint that just has words up like this. If, however, I'm dealing with people who normally think in terms of finance, whether it's accountants, financial directors, it may just be other businessmen who think in terms of the money, then what you need to do is to speak their language. You need to be getting the numbers up on the screen and talking to them in numbers. Similarly, if you've got someone who's very creative, or maybe they're an engineer, then they may be thinking in terms of drawings. And I think, again, if you can draw the problem or draw where you're at in some form of diagram, immediately you're getting through to their perception and how they see these things. One of the things I think one has to be very careful of in going into any form of negotiation is making an assumption that what's important to you in this negotiation is important to them. I've seen a number of cases where you've looked at it and you've thought, well, it's all about the money. It's all about how much they can get. And this is a dispute about the money. And then as you start to talk, you start to ask the questions, well, why is this important to you? Why did you do that? Why did you reject this proposal? You start to realize that the money might just be a symbol. It might be, it might relate. It's the position they've adopted. They want the money, but it's not actually what's driving the dispute. This came home to me very clearly in a case I had. It was rather a sad case where the parents had given money to their son in anticipation that he was going to marry his long-term girlfriend and they were going to buy a house. And so they'd given the money to the son to buy the house. And the son and his girlfriend, his fiancée, had bought the property before they got married. Sadly, the son then died before the marriage took place. And it meant, because of the way the lawyers had dealt with the transaction, that the girlfriend now owned all of the house. And the son's parents, who had put the money into the house, had no legal right to any recovery, even though the relationship, obviously, with their future daughter-in-law was not now going to happen. So they ended up suing the lawyers because they said, well, you should have protected our position. And so I was involved in trying to negotiate a sum of money that they said they'd lost, and the insurers for the lawyers were saying, well, no, we don't think it's worth that. And we were going back and forward on the money. And then it became apparent to me that actually it wasn't about the money at all. And I was able to stop the lawyers, and I turned to the mother who was running the negotiations for the parents, and we got a different conversation going. And she said, yes, we can settle now because I think my son will be happy with what we've done. And it was all about how they were reconciling their own lives and the death of their son. And now that's quite an extreme example, but I think this need to value sets of the people that you're dealing with when you're negotiating is very important. This often comes out in emotions. And that case I've just referred to, that was emotional. And at the end, there was a real sense in which we all felt we brought the matter to a conclusion. Now, when I was a young lawyer, I like a lot of lawyers, I used to think, well, emotions are not for lawyers. You know, I'm a lawyer, I'm not an emotional person. I'm here to use my rational mind to find solutions. And it's fair to say, as I've got older, I've realized how important emotions are, particularly in negotiation. And I think if we shut down the emotion, we're missing a great opportunity to find out what's really important and what's driving these negotiations. People very often need to speak. They need to be heard. And if you're listening to someone, it's really important to not only to hear what they're saying, but to hear how they're saying it. There's the story of an American lawyer who would never bring his client to mediation, and when asked why it was, he said, "Well, I don't want my client to have the chance to tell the story. I don't want him to have the chance to be heard. I want him to remain really angry, because the angrier he is, the more he'll want, and the more he'll seek from the other side. Whereas if he's given a chance to explain and to be heard, then he'll settle for less." Now, I thought that was interesting and cynical, and but it makes a point. So, if you hear someone in a negotiation, you're in a meeting, and you can see someone getting really worked up. You're looking at the signs; they're getting red in the face. They're using lots of gestures. They're getting very angry. The natural response the natural human response is to respond in kind, is to get angry yourself, or to get very defensive. You know, you cross your arms, you maybe you don't look at them, or you stare at them. And I think there are a number of things that in play at this stage, and it's quite difficult. And I think this is a real challenge for you if you're on the receiving end of this, because your natural instinct is, and what the brain is telling you to do, is the fight or flight mode. Well, if you're in a negotiation, you can't flee, so you're left with fight. And what you have to learn to do, I think, to get beyond that, is to, I was going to say, absorb. I think it's, and I'm going to come on to this in a moment when I'm talking about communication, it's to try and step back one and think, well, why why is this person so angry about this? Particularly if they're being angry about something that's taken you by surprise. And you can start to think, well, why are they angry? What's going on? And have I missed something here? What's um, is there something that they're not telling me that I need to find out? Now, you have to be a bit careful as to how you respond here, I think. And sometimes I think culture is quite important. I do remember coming out of the, there's a session at the ICC, the International Chamber of Commerce in Paris, where they have a mediation competition every year. And they have universities from all over the world there. And I remember coming out from the building and seeing one of the Italian teams who had just finished their session. And they were obviously discussing how it had gone and what they thought had gone well and what they thought hadn't gone well. But if you listen to them, you would have thought there was an enormous argument going on, listening to watching the gestures, listening to the raised voices, the way they were interrupting and arguing with each other. But actually, I could see from other parts of the body language, they were just communicating. That was how they communicated. So definitely one has to be aware of how emotions are sometimes shown in different cultures. I think the other thing, and certainly I've come across this in my mediations, is the fact that people use emotion deliberately. They manufacture their anger. And certainly I've thought at times of awarding a mediation Oscar to someone who has been, or who's appeared to be really angry, but really I thought, no, that's a put on show. You have to be careful because it may be, it may not be, but you have to keep that in the back of your mind as well. I think it's absolutely one of the things that one learns when doing mediation is that you follow the emotion, particularly if the emotion is unexpected. You try and follow that through and find out what the reason for that is. Symbols are also important and can be used in negotiation. And I think one has to look very carefully at symbols. Apologies are enormously powerful in a negotiation, particularly if there has been fault at some stage, to be able to say sorry and to genuinely show that it's meant can be a very powerful force. But if you're going into a negotiation, I've seen this on a number of occasions, where particularly there's a claim against a professional firm and a member from the professional firm is saying, we're really sorry this has happened. And then you move on into the negotiation and they say, but we're only going to offer you £1, £5. In other words, a financial response that's wholly inconsistent with the apology. It removes all the power of that gesture. So you've spent a bit of time trying to make sure that you're being heard, that you perceive, you understand where they're coming from and what they're hearing. You've tried to study the emotions. You've looked to see what emotions are being displayed, trying to understand. And all the time, I'd be encouraging you to be asking these questions. And so we move really into the heart of what this negotiation is all about, I think. I mean, this is the guts of it. And you'll see I've put on this slide the concept of active listening. What do I mean by that? What it means is that the person who you're talking to, the person who you're negotiating with knows that they're being heard. And so, that's so important in terms of moving people on from the position that they've adopted at the start to moving them to what's really important, what's really driving the dispute. Because that's what you want to find out. I often say at the start of my mediations, there's only one thing certain in this mediation, that if the parties don't move from where they are now at 9 o'clock this morning, this isn't going to settle. How far they have to move or how they've got to move is another matter. But if they maintain the position that they have at the beginning, this won't settle. And so what you're seeking to do is to move them on, to find out what the interest is. And this is the key. And active listening is, first of all, letting the other person know you've heard them. And repetition is a very powerful tool. So they say something to you and you don't immediately respond. You actually stay with what they've said and you repeat. So what you've told me is this, what I've heard is that right? Give them a question, give them the opportunity to explain, give them the opportunity to expand. One of the problems with lawyers in meetings is that we don't listen. I'm sure you think you do, but actually, if you think about it, what you're often doing when someone else is speaking is waiting for them to draw breath so that you can jump in and rebut what they've just said. And what you need to do to move the conversation on is not to do that, but to stand back and say, and make sure that the other person has actually heard you. It's only once you've done that you can then move on to what I've called reframing, because this is where you're helping them to understand what they've actually just told you. So if someone says to you, I'm really keen to sell my business, but I need, I don't know, £1 million for the business. And you can say, so what I'm hearing is that you'd like to get £1 million for that. So why the figure of 1 million? And then we might move on and say, they might say, well, I'm keen to have enough money to look for my retirement. And I've worked out that this is what I need in order to fund what I need for my retirement. So you reframe it. So to put it another way, what you're looking for is a form of income, a form of security for your retirement. So rather than 1 million now, you might be looking for an income in the future. And so if we were to pay you £500,000 now and £100,000 a year for the next 5 years or for the next 6 years, would that work? And all of a sudden, you've moved the conversation on for the price of the factory having to be, or the business having to be £1 million, to it having to be half that at the moment, but more going forward. Empathy is really important where something's gone wrong and they're looking for compensation. And I think it's difficult where you are negotiating. I think as a mediator, I can use this very effectively, but there are occasions where I've seen in negotiation where the other side has essentially been establishing a relationship with the claiming party, and to ask, well, what was the effect of that? And then to be able to show some empathy and say, yes, well, I know what you feel because actually I had a similar situation. And all of a sudden you've got the people talking about something that they can share a common interest. This came home to me very strikingly in a case I had a few years ago. It was a claim in relation, I think it was in relation to the building of trucks, of lorries. And what had happened was a third party who had been the middleman between these two had taken a lot of money and caused loss to both sides. And so really the person who was claiming and the person who was defending, they both suffered loss. But the way the law worked meant that one had a much better claim and was likely to recover money. But actually, once I was able to move the discussion on to the effect on that, what was the effect on the business? How has it affected your business? And they then actually had a common conversation. Well, this is how it affected my business. This is how it affected, and this and the other person said, but this is how it affected mine. They then shared a common interest, and that actually settled that case. Once I put the lawyers in the background, and the two businessmen were saying, well, okay, yeah, we could do some more business together, because they've been able to share the empathy. How do you get there? Well, I think the key that you have to look at is this whole concept of influencing. I come back to what I said earlier. People get involved in disputes, they issue proceedings, they threaten claims, they pursue claims because they believe they're in the right and the other person is in the wrong. And their belief is fortified by their view of the facts. They prioritize the facts that are important to them, and they minimize the impact of facts that are against them. And I see it all the time. You see people who, when there appears to be a fact, a piece of evidence that's harmful to their case, they'll explain it away. They'll say, oh, well, that was unusual. Or that witness, well, he won't be believed. Whereas their witnesses are going to be believed. Their experts are the best. And so if you're wanting to move that person on, and if you're wanting to move that person away from their belief in what's in the justice, the rightness of their position, you're not going to be able to do it by going head on. You've got to influence them. And you've got to talk to them in language and in a way that enables them to move on. Because short of actually putting them in front of a judge and the judge saying to them, you're right and you're wrong, the only way you're going to get movement is actually by persuasion. And I often say in my mediations, I've got no power to compel, I've only got a power to persuade. So how do you influence people? Well, a very important, as I've just been saying, a very important role is being listened to, being heard. If someone thinks they've been heard, then they'll be much more open to listening to what you have to say and why you see it differently and why you're putting forward a different point of view. Curiosity, I think, is a really interesting and sometimes little used tool to get people to change their mind. Get people to think, well, why? Why is it like that? It's often said that there are, well, I say it's often said, one of my colleagues says, there are three types of offers you can make when you're negotiating. You can make an acceptable offer, you can make an unacceptable offer, or you can make an interesting offer. An acceptable offer, if you make it at the beginning, probably means you've offered too much or you've accepted too little because it's been accepted straight away. And you probably haven't necessarily got the best deal you could. And similarly, an unacceptable offer can simply put things on the back foot. You're just being, the other side think you're just being unreasonable, or you haven't heard them, or you haven't, you really don't understand what this case is about. But an interesting offer is one that gets their attention, where they say, ah, well, that's interesting. Yes, well, we're not going to accept it, but we can see why they're offering that, or why they might be willing to accept that. And we can work with that. Yes, we could move a bit on that because we can understand what they've said. So I think this idea of curiosity, getting the other person engaged, is really useful. And again, when you're talking, I think brevity is 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 fantastic. Um, Lawyers are not very good at brevity, in my experience. Um, we we're very hesitant to leave anything out. We want to put everything in because we're just worried that we might have missed something. But actually, if you can just work out what are the keys, what is absolutely essential, and what are our really big points, you don't have to give up anything else, but actually to focus on a few, just on a few issues, you're much more likely to get a positive response from the other side. If you put everything at them, then the really important points get lost in the morass of everything else that you're putting forward to them. Whereas if you say, this is all about 3 issues, isn't it? It's all about the following 2 points or whatever, and explain why you think you're going to succeed on those and why you don't think they're going to succeed. That can be very powerful. The manner in which you approach people. So often in negotiations, lawyers come along with the intention of teaching the other side, showing them why they're wrong, showing them why they're going to lose. And you're there to tell them all the things that are wrong about their case. Comes back to this question of belief. If you do that, people are bound to react in a very defensive manner. Whereas if you come along in a much more open way, and your manner is one of wanting to learn, and I think one can do this quite cleverly. A way I very often use is to say, look, it's probably just me being slow, but I really don't understand how your argument works. I really don't understand why you're claiming so much money when the only evidence you've produced is for this. Or I really don't understand why you think my client should be liable for this when all you're saying they did was this. So put it in a way that enables them to say, well, this is why, rather than simply say, well, you're completely wrong and the court won't accept it. I think if you just accept that, I suppose you're accepting you might be wrong. You don't think you are, but you might be. Again, you open up a conversation. But it's really important to maintain focus. I do think that's the key. In negotiations, you often have this question of who goes first. If you're wanting to move to another position, you've got to think, well, who is it a sign of weakness if we go first? Shouldn't we maintain our position? Perhaps, but equally, I think, if you go first, you've got the opportunity of setting the framework for the negotiation. And I think that can be very key as to how the negotiation proceed. You'll see I've quoted here from the definition of negotiation from the Oxford English Dictionary: to confer with another with a view to compromise or agreement. And I've often seen in the mediations a great advantage in someone going first and saying, well, we are here to compromise. We accept that we're not going to get everything that we want. But actually, what we think is really important is this, and we're willing to give up, and whatever it may be. And in so doing, they're, in a sense, setting the parameters of negotiation. They're setting the framework for those negotiations. And you could very much find yourself on the back foot if you haven't gone first, because what you're then going to have to do is to respond to their negotiating tactic. And particularly if you've gone into these negotiations with quite a clear understanding of how you're going to negotiate, that can be very, very successful, particularly if you've got a number of steps that you can see your negotiation going in a particular direction. And as you get to solutions, to outcomes, you've gone through the conversations, you've got as much as you can out of them in terms of what they want, why they want it, what's important. You're now looking at solutions. I'm a great believer in trying to be collaborative. I think a lot further in negotiation by collaboration. It's not a sign of weakness, I don't believe. When I started mediating, definitely mediation was regarded as a sign of weakness. If you're going to mediation, there must be something wrong with your case, or you're worried about the judge, you're worried about the court. And these days, I think as the market's moved on, it's almost the other way around, that you will be substantially criticized if you don't go to mediation. And so this concept of collaboration, I think, is not a sign of weakness. And so to keep the communication going, what works for you? Why does this work? Why does this not work for you? Is there another way of achieving it? Brainstorming, putting solutions out there and saying, well, supposing we try this. I think all these are ways in which you can, as it were, pull someone away from their position, and particularly if you've given a bit of thought to what you think their interests are and say, well, doesn't this work for you? Now, I'm conscious that we're getting towards the end of the session, and I've